think immediately after this hearing for John Leisure. Nice to meet you.
Can we just back like that? There we go, backwards.
Can you see us?
Yes, I can. Thank you so much.
Good morning, everyone.
Good morning.
We'll go ahead and get started. We are on the record with docket number 57065, Commission staff's petition for an order appointing a temporary manager to Windermere Oaks Water Supply Corporation. My name is Christina Denmark. I'm the administrative law judge assigned to this matter. This is a pre-hearing conference being held in person at the Public Utility Commission's offices in Austin, Texas on October 22nd, 2024. The hearing on the merits will be held this Thursday at the Commission's October 24, 2024 open meeting. It's now 9:32. At this time, let's go ahead and take appearances of the parties, starting with Commission staff.
John Leisure on behalf of Commission staff.
Jeff Walker on behalf of Windermere Oaks member and board member.
So you're representing the mayor in this?
Yes.
Okay. And the Carlton Law Firm is not involved?
None.
Okay.
Trying to cut costs.
I'm going to go ahead and start off with kind of the flow of what's going to happen on Thursday during the meeting. So this hearing is going to be held during the Thursday's open meeting. Thursday's agenda is extremely long. No surprise there. It's been long every week, every time we have one. So I want everybody to be on the same page so that this goes smoothly and expediently as possible. We'll start with an opening statement from Commission staff. Followed with an opening statement from the utility. We'll then move on to witnesses. I'll swear them all in at once right before we get them started. We'll have direct and cross-examination followed by any questions that the commissioners may have. We can discuss designating order of the witnesses when we get down to the witnesses. And then after witnesses, we're going to have our closing statements from staff and then the utility. Each party is going to have 1 hour to present their case. That 1 hour is inclusive of open, direct questions by the commissioners, cross, and closing. I'm going to be keeping time. I'll let y'all know throughout the proceeding as each witness comes up, as you finish your opening, how much time you have left. And we're sticking to that 1 hour for each side. Let's go ahead and move on to exhibits. Commission staff, you have identified and filed 29 exhibits. Are you moving to admit them all at this time?
We are, yes.
Are there any objections to any of the exhibits?
Randy, but I have a question. Does that include the ones that were submitted yesterday to the docket?
Yes, that would be the
Additional ones?
8, perhaps 9 additional dockets, exhibits. That'd be exhibits numbers 21 through 29.
Any objections?
I don't.
And it looks like, under here, you have 13 exhibits, including
The two from last night.
2 from last night.
That's right.
Are you asking for those to be admitted at this time?
Yes, I am.
Do you have any objections?
I do have objections to exhibits number 2 and number 8 on the grounds of relevancy.
Okay. You said 2 and 8?
That's correct.
Are those the only two?
Those are the only two, yes. And no objections to the ones filed on Sunday, exhibits 12 and 13.
Oh, the ones from last night?
Those are,
Yeah.
those are.
What is your response to?
Well, I'm going to start from the bottom up. I'll go from number 8, the real estate broker status report. I think that's very relevant in regards to, we do have a piece of property that is been under a real estate broker's, I'm going to say authority, may not be the right word, but under a contract for us to sell it. And we did have a potential buyer. We have a couple more that are in the wings. I've spoken with them. The reason why it's relevant is it does provide a substantial amount of revenue to the corporation, and we are concerned about if a manager is appointed that and he has control of assets that real estate such as significant as that to the corporation is kind of reviewed before he goes out there and possibly has a fire sale to generate revenue, as you'll see from my explanation about where we're at from a financial standpoint. We just don't want them to, go out there and have control of all of their assets and say, hey, we need funds right away. We're going to sell that one right, at a discount. So we want to be engaged in that, and that's the reason why the status report came about, is to give everybody, including the commission, because we told them from the beginning, even staff came through and said, hey, you might have to sell some of the assets. We got on that situation right away and have been actively involved in that, and that's just a status report to tell everybody where we're at with it and what the potential income is from that sale.
And number 2.
I think number 2 is relevant because I did submit a PIA request from correspondence between Ms. Lander and Ms. Flunker in regards to this year. Just simply wanted to see the dialogue between the two, because it's ironic that some of the things that are noted in the petition for management seem very similar to what we've been hearing within the community. And I think it's a just request to find out what correspondence have been going on with with Mayor Lander in regards, and I've been kind of stonewalled by the PUC. I think there's also relevant information in there. If you look at what I provided as far as that document, that PIA request, coming from the PUC, there is a statement in there that claims that Ms. Flunker is the ratepayer representative, Patty Flunker as attorney representative for the ratepayers of Windermere Oaks Water Supply Corporation, and that is directly from the PUC. That is an actually false statement. So I think it's relevant that I'm allowed to see some of those correspondence and be able to respond, because that is a false claim. And that is a document published by the PUC. So that's my reasons for bringing it into this.
May I respond?
Yes, you may.
I'll start with Exhibit 2. While I understand your desire to have the PIA information obtained through this request, what you've submitted into evidence is the letter and none of the correspondence. I believe that's because the Attorney General's office has not actually ruled on whether or not this information can be withheld or should be delivered. I would argue, and Commission staff would argue, that this particular exhibit, being as it is just the letter seeking advice from the AG's office as to whether or not these documents must be submitted, itself has no bearing on this case.
May I read that? I will keep it brief. The AG office, when I spoke to them recently, as of early of last week, said that they'd have a ruling to me on the 21st, which was yesterday, which did not happen. They are way behind in providing me a ruling on this. This document was sent up on August 1st of this year. They have stonewalled me for some odd reason, which gives me speculation of something going on there. And I think it is relevant of why I, as a board member, can't receive, a public information request from a PUC staff attorney who has worked with Windermere Oaks for a very, very long time. And I just find that ironic why I've been stonewalled on it and why I've not been able to be provided by that. Now, I know that the AG's office is involved, but according to them, I'm supposed to receive a response back on the 21st. So, my statement on that.
All right, did you have a response on those?
Yes, similarly, the issue here and the rationale for the seeking temporary management is hostility towards the commission. While I understand that a portion of the argument against that might be the financial status of Windermere Oaks Water Supply Corporation, this particular document, again, does not address or rebut the arguments presented by commission staff on the petition. In the interest of time, I do not think that there is anything probative that can be obtained through examination of this document, similarly to document number 2, previously discussed.
I have to object to the word hostility. I don't think there's been any hostility towards the PUC or towards anything. I have been working with your staff, Merritt Lander, for almost 2 years. At one time, I did support what the ratepayers were doing up until I saw the Cobos memo on the 13th of December of this year of 2023. And when I started looking at the rates and what was going to happen to the corporation, I immediately went on a campaign in January, February within my community stating what was happening with these new rate appeals. And it was not hostile. There has been no hostile correspondence. Recently, yes, when Ms. Lander called me in regards to telling me about this petition and not giving me a heads up and not giving the law firm that represents us a heads up, which they engaged with Ms. Lander about that, that's where the hostility came. It did not come from the board, did not come from the membership, and did not come from me. And if you want to include those other documents that were submitted yesterday, yes, I did have an email that went to Ms. Lander because I don't think that the PUC staff supported us in this endeavor, which I asked for in many documents to her and to other people within the PUC when this all came down March of this year. So I don't think it's hostile. I have an issue with that statement.
If I may issue just a brief response. The term hostile, as used in the petition, more or less serves as a term of art. Hostility is in reference to failure to comply with commission orders. It's not a suggestion of tone or aggression. That is just how the term is used in the statute.
Got it.
Okay. I think I have everybody's arguments on those 2 exhibits. I will defer ruling at this point and take everybody's arguments under advisement and issue an order on those 2 later today. We will admit and go ahead and we have all of commission staff's exhibits 1 through 29 are admitted. And then we have Windermere's 1, 3 through 7, 9 through 13 are admitted. And like I said, I will take your arguments under advisement and issue an order later today on those 2. Let's go ahead and move on to witnesses. And we're here today just to discuss procedural stuff of what's going through,
Okay.
arguments, save those for later. Witnesses, commission staff. Do you have witnesses?
Yes, Your Honor. We have sought to obtain fact evidence from Patty Flunker and from Jeff Walker.
Windermere, your witnesses.
My witness include Merritt Lander, Brian Garzeau, who is a member of the community as well as a board member. I'm not sure about Tammy Hagar, if that might change to Hal Landon, who is the CEO of the corporation, but there with AWR Services, can talk to many of the issues within the docket, as well as Patty Former.
Discussion on witnesses.
Yes, Your Honor. Commission staff has objections on calling Merritt Lander as a witness. We also have objections as to Tammy Hargett or to whoever may replace her. If you would permit, I would like to start with Ms. Lander. Ms. Lander has no factual information about the non-compliance of Windermere Oaks. Ms. Lander has been assigned to this case. Commission staff argues that by placing Ms. Lander on the witness list, this is to serve as harassment only. There is no information that Merritt Lander has that could be of any value defense-wise for Windermere Oaks Water Supply Corporation. Concerning Ms. Haggard, Commission staff is curious as to what exactly she could add to the table. A quick review does not suggest that Ms. Haggard has the proper credentials to serve as an expert witness. I see no affidavit giving me information as to the drafter of the AWR reports. To the extent Ms. Haggard is going to speak about the contents of the AWR reports, that is hearsay. There is no suggestion that she had any role in drafting these reports. So again, while these reports have been admitted as evidence, and they are business records belonging to Windermere Oaks, a member of the board for Windermere Oaks can speak as to their contents because they are their records. But I have nothing that indicates that these are records produced or kept in the normal course of business by Tammy Haggard. And similar objections would be raised if she would be replaced with the CEO who was named during this hearing.
I do have a response. Well, I'm going to start with the latter one because it's on my page. The reason I have put Ms. Haggard on there is to validate information that was identified in the petition. And there is an email directly from her that's in my packet that was submitted about how operations were being handled, how water boil notices were sent out, how and why they were sent out. That was the email directly from her. Also, if you look in the SI environment document that I submitted, it did reference Tammy Haggard as being the Director of Client Management Services who worked directly with us on a day-to-day basis. She can speak as an expert witness in regards to our physical operations and our physical plant and exceptions that we have out in the Windermere Oaks in regards to our facilities and our facility management, which is part of this docket because it was part of this petition in regards to some of the things that were identified in there. So I do find her a very credible witness because she has lived with us for almost coming up on well over a year and directly with us since March of this year. As far as Merritt Lander, I think she does have a critical role in this. I have worked directly with Merritt for, like I said, over 2 years. I think she brings incredible information about our facilities, our operation. She has an incredible history. I would like to drill down into what the expectations were when the rate appeal was put into place and the compliance filing, since I was one of the authors of the compliance filing, and how those two in parallel really affected the corporation. They were brought to a rate appeal and a compliance filing almost simultaneously. I don't know how you expect to cut rates and provide compliance capabilities with expected cost when you're getting such a drastic rate reduction. And I think that was orchestrated by the PUC staff. And, you know, Ms. Lander is the only one that I'm gonna, that I've only worked with, so she's the one that's on the top of my list. So I'll leave it at that. So,
Again, under advisement. and,
Okay. Thank you.
Discuss that in our order later. Do we want to talk about order of witnesses? It looks like we have Ms. Flunker, both of you all have her listed. Commission staff, you know, you're starting off, do you have a preference on order?
I will need to confirm with Ms. Launder afterwards. I can tell you that if this was my sole case, I would have Mr. Walker go first and then Ms. Walker.
Both Jacksons.
Do you have any order on?
No, I
your
think,
list?
you know, I have no problem going first. If Ms. Flunker wants to go after me, and then Brian, that'd be awesome. I have no problem with any of them.
And just to.
And then supplement it with if the two other ones get in.
Are either of you requesting to invoke the rule on exclusion of witnesses at the hearing on merits?
Commission staff would like to invoke the rule.
And neither of you are intending to offer any further witnesses on Thursday, correct?
To the best of staff's knowledge, no.
Yeah, to the best of my knowledge, no, I'm pretty well set. Thank you.
Don't we have any other pending motions at this time? Is there any other business to discuss this pre-hearing conference?
No, Your Honor.
I do not have any.
Okay.
Shortest one you've done, probably.
Sadly not.
Bummer. I wanted that record.
Okay, we'll go ahead and adjourn this pre-hearing conference Thursday. Here, not sure when that'll be up, but it
Understood.
is Thursday.
And they're done now. Thank you very much. Thanks,
I'll have
Jen.
an order out to y'all
Yeah.
today.
And it was Denmark, right?